And 9 months later, for telling us we can bring another contempt hearing is kind of defeats the whole purpose of this program. The whole purpose is to get the money to people when they need it now.
I would just tell everybody to hang in there.
All right, good morning, everyone. We are on the record in the case of Payne versus D.E.T.R, case number civil 20-755. I'm Judge Breslow, presiding judge in Department 8 of Nevada 2nd Judicial District Court, presiding from Washoe County, Nevada. At this time, I would ask the court clerk, Ms. DeGaynor, followed by the certified shorthand reporter, Ms. Zinn, to please identify themselves for the record.
Good morning. Amanda DeGaynor, court clerk, Washoe County, Nevada.
Thank you.
Isolde Zinn, Washoe County, Nevada.
Thank you. Counsel for plaintiffs, starting please with Ms. Jones and Mr. Thierman.
Good morning, everybody. My name is Leah, L-E-A-H Jones, Plaintiffs Counsel, Washoe County, Nevada.
Thank you.
Mark Thierman for plaintiff, also Washoe County, Nevada.
Thank you very much. Counsel for the state, Mr. Ott, and if you would please as well identify your client representative.
Thank you, Your Honor. Greg Ott on behalf of the state from Washoe County, Nevada, not joined by Mr. Whitney today, but Director Cafferata is present as well. Should also note for the court that Ms. Allender and Mr. Schmidt, who previously provided testimony in this matter, are available if needed. They're not currently joined as panelists, but if the court wants to hear from them, they're around.
Appreciate that. Thank you. All right, this is the time set. Well, let me back up. We are proceeding remotely this morning, as we have for our last several hearings in this matter, on account of the global COVID-19 pandemic. Court is allowed to proceed this way pursuant to Nevada Supreme Court Rule, Subpart 9, regarding simultaneous audiovisual transmission, as well as recent administrative orders of Nevada 2nd Judicial District Court. These proceedings are open to the public, either via a link on the court's website or via, as I understand it, the court's YouTube channel. Okay, we're here today because the court set on December 3rd a status hearing this morning to gauge compliance with both the court's prior order of mandate and then the further discussions which ensued on December 3rd, leading to the court's oral pronouncement that the court found the state in contempt, followed by, shortly thereby, a written order of contempt on December 8th. We will all recall, both from the hearing and the court's written order, that I directed the state no later than December 24 to move forward, at least with those 9,000 plus individuals who had begun receiving benefits and had them stopped, who had not yet had them resumed because of the apparent stated belief by the state that those recipients either were or had available benefits with P.U.A, P.E.U.C, or S.E.B. So this hearing today was designed to gauge compliance with the court's order of mandate. I am aware of the state's filing on December 24th of a notice of purge of contempt citation. The state therein identified steps that had been taken and were being undertaken at that time to come into compliance with the court's order. The court reviewed the Administrator Parvin's directive, email directive to everyone that she supervised with respect to restarting payments and or not discontinuing payments if they were in progress pursuant to this court's order of mandate. The court also reviewed Ms. Allender's declaration, where she identified the number of people that D.E.T.R believes the state's actions have now responded to, consistent with the court's order. Ms. Allender, as we all recall, is a senior administrator with D.E.T.R with oversight responsibilities for the program. The court notes from Ms. Allender's declaration, as well as Exhibit 3, that the state filed on December 24th, which is a chart, reconciling the numbers from exhibits offered at the December 3rd hearing with what is going on right now, as the court understands it. Apparently, the state maintains that with respect to the 9,000 plus individuals that the court found ought to have been restarted but had not, and hence the order of contempt entered, approximately 5,758 claims had been restarted by December 24. Approximately 1,122 had not, with the state's firm belief that they were captured as part of the court's prior directive that clear and convincing evidence of fraud would be sufficient grounds for the state not to resume payment. And then there's a third number of 3,037 that it appeared to the court, although I'll need a little explanation on, that the state maintains those as to those people, they were already receiving payments. So apparently there was no need to be restarted pursuant to the court's directive on December 3rd. Added all up gives a number between 9,000 and 10,000 people. So as the court understands it, the state maintains, both today and as of a week ago, that it now is in compliance with the court's initial order of mandate as further confirmed at the December 3rd hearing and the December 8th order. The plaintiffs, and we'll hear, of course, from them shortly, have responded. They have filed declarations of 3 individuals, Mr., and if I mispronounced their names, I apologize, Mr. Michael DeShalit, who currently is an unemployed magician hypnotist. Ms. Andrea Rabinowitz, currently unemployed dental hygienist, and Ms. Lisa Malaya, currently unemployed individual who works as an animal boarding attendant or jobs associated with that. Plaintiffs' declarations identified the struggles that those 3 individuals have encountered in receiving benefits that the plaintiffs maintain they are entitled to and otherwise would be captured by the court's original July order of mandate or the court's December 8th order. Court also reviewed Ms. Jones' declaration and the exhibits attached. Exhibit 1 being the 2019 Unemployment Insurance Program letter from the Department of Labor. And specifically, the court noted in its review of that exhibit, page 2, where the authors advise that states apparently are to continue unemployment and insurance payments even if concern is reflected by virtue of overpayment, belief, or fraud, until an official determination of ineligibility has been made. The court also noted from Exhibit 1 to Ms. Jones' declaration that on page 6, the authors of that program letter noted very correctly in the court's estimation that fraud determinations usually require an analysis of credibility and intent of the applicant, thus suggesting that these type of determinations do not lend themselves neatly to a mere two-dimensional review, computer review, algorithm application. Court noted as well in Ms. Jones' declaration, Exhibit 2, that being the July 21st, 2020 program letter number 16-20. So unlike the first program letter, this is recent, just off the press. That letter, among other things, the court takes away that many states and many administrators of the pandemic assistance programs are confronted with myriad questions and that have required further thought and response from the federal government. Issues have arisen, questions have presented themselves, real world application of the payments under the law when met with different circumstances for different individuals and different states at different times have led there to be a host of questions that have been presented to the federal government. The federal government then in part responded to many questions with their view on how states should respond when confronted with these types of issues. The takeaway for the court, among the other things, is it shows exactly how complex and challenging some of these issues can be for those administering the program. Not that that was not already apparent, but it certainly became even more clear by virtue of reading Exhibit 2. And then finally, in that Exhibit 2, the court did note, and I think it was question 23, that a key component of the question and answer guidance was to make sure that claimants were afforded due process before benefits were either stopped or alternatively denied. And then finally, Ms. Jones attached Exhibit 3, those being certain excerpts from the recent Consolidated Appropriation Act. The court candidly was unclear on what the takeaway for purposes of this hearing or any future hearing should be, and I'm sure the plaintiffs will explain that to all involved. So where does that leave us? I'm aware that the state maintains that it has now substantially complied with the order of mandate from July, and in particular, the December 8 order in which the state was found to be in contempt. I realize the plaintiff's position is not exactly. I'll hear from both sides in a moment. I just want to explain this one concept. As we all know, the pandemic has affected virtually all walks of life over the last 8 or 9 months, and it's not an understatement for the court to say that it's likely to continue to do so for at least that amount of additional time, if not more. Multiple jurisdictions are being faced with a tension between due process and logistics, and administering the C.A.R.E.S Act benefits available both for the recently unemployed, the long-term unemployed, gig workers who previously were not eligible for benefits, things like that. So it's not lost on the court that this is not a unique problem, unique to Nevada, unique to Southern Nevada. It's happening countrywide. But the court's philosophy in applying the law to the facts that the court finds here is this. In the world of the pandemic, in one sense, a level of people's constitutional rights may be temporarily relaxed, but they're not asleep. And so the court has to find the right balance here with the overlay of the considerable economic suffering that our state uniquely has experienced. So what we're going to do today is have argument on, I'm not likely to need testimony, but have argument on whether the court believes the state has made substantial compliance with the order of mandate, and whether the state has now worked its way out of a contempt so that the court should take no further action, or whether, as I'm assuming plaintiff will argue shortly, it has not. Let me start with the state, please. Mr. Ott, do I have it? These were the court's preliminary comments, but do I have it generally right? Does the state now maintain it's abided the court's order, it's doing everything required, and it's making substantial progress? Mr. Ott.
I would say you have it substantially right, Your Honor. There is maybe a slight distinction that I think is important to make. You will see the numbers from Ms. Allender's declaration are slightly different from the numbers in Mr. Schmidt's chart. And the reason for that is with Mr. Schmidt's chart, what we wanted to do was instead of continually trying to explain how the numbers change and the numbers shift and people move as the cases get worked, is to say, we gave you this universe of a number of people that were the 750 claims that were in Exhibit 17 at the prior court hearing. We want to track exactly those claims so that the court can see exactly what happened to those people. Now, we're aware that there are people outside of that universe of 750 claims who may be impacted by the order of mandate, and those people still need to be worked as well. But the court found us in contempt with regard to those 750 classes, those excess 9,000 people. So those were the people that were reflected in Mr. Schmidt's charts. Ms. Allender's declaration reflected more people than that. So we didn't just stop at the 750s. So for instance, the easiest one to look at is, I think, the ones that were held for clear and convincing evidence of fraud. Ms. Allender's number is 1,122. Mr. Schmidt's number is 865. So the delta there is cases that were not in that 750 that were additionally worked and reported on to the court. So with regard to, yes, we believe that, and have not learned of anything since the filing on the 24th. We wanted to get that to you on the 24th to know that that was our position on the 24th. Have not received information since then to believe that those 750s have not been taken care of. Are there additional claims and additional things that need to be worked? Yes, that was clear in Mr. Schmidt's testimony, where there was on the 17th, where there was the 750s, and then there was the fraud, and then there were other miscellaneous buckets. The court held the contempt on the 750s. That has been the focus, but those other claims are not being ignored. They just were not the priority, not given the same priority as the ones in the 750. So that is the difference, or that is the explanation of the difference in the numbers there that hope the court understood, but I wanted to give a little bit of extra context there.
Well, thank you. I did note that the plaintiffs were observed that the numbers were different. And so you put that in context. I guess I have another question, Mr. Ott, before I hear from Ms. Jones and Mr. Thierman. And that's this. I realize that the three declarants that the court identified earlier that plaintiff just filed about a couple days ago. I'm not sure if the state has had an opportunity to read, consider, and vet those at all. But if you have, what do you make of those three people? And I'm not, by this question, inviting every single person who believes they're still, that is frustrated, is trying to do what they can and believes they're being wrongfully denied benefits to pick up the phone or send an email or fax to Mr. Thierman, and then it ends up in a declaration. It's not the court's intention to drill down that closely in these hearings. Nevertheless, the plaintiffs did identify three people that they believe ought to have been paid or restarted by now. And if so, my question to the state is, have you had a chance to look at that? And if so, do you have a response that either you or Ms. Cafretta could share?
Yes, Your Honor. And I want to be careful because these three individuals who have submitted declarations are not plaintiffs. As far as I know, they're not represented by Mr. Thierman, and they have not waived any confidentiality requirement or any confidentiality provisions under NRS law. So I can't speak to the specific details of their case, other than to relay to the court that those cases have been reviewed, and go back to my previous comments, which is to say that I do not have any information that would cause me to need to amend the December 24th filing that says that those universe of 9,000 have been purged. There are other issues that are continually being worked and given priority. At the same time, there's also new legislation coming down, which is a whole nother burden that we don't need to address now. So I want to try to give the court information, but at the same time not violate the confidentiality provisions of those individuals, and I hope I've done that.
Thank you. With your permission, Mr. Ott, I would like to address Ms. Cafretta and just ask her generally how things are going these last 3 weeks since our December 3rd hearing and the December 8 order. Any objection, Mr. Ott, if I do that at this time?
No, Your Honor.
Ms. Cafretta, that's my question. How are things going?
Thank you, Your Honor. We have, as our attorney has let you know, we've been focused on coming into compliance with the order. We've reiterated that the urgency of that and continuing to stay in compliance at all levels of the organization. At the same time, we had a more exciting than necessary Christmas week when we were preparing to implement the new law that Congress passed, and then it was not signed by the president. So all of the extensions in the C.A.R.E.S Act expired for one day, and we were required by the Department of Labor to turn all those programs off and provide notice to people that they were expiring. And then the president did sign the bill, and so now we've had to turn around and absorb what's in the new bill, which is largely the same as the old bill, but has some additional refinements, clarifications, new programs, and new rules, which we have to incorporate into our program. So our focus largely has been trying to figure out, to the extent possible, how can we continue to provide benefits in an uninterrupted manner in programs that were actually stopped and then restarted with new rules. So not the quiet week between Christmas and New Year's that most state agencies usually get, but we are focused on getting as many folks their benefits without interruption as we possibly can.
Thank you very much. All right, who would like to address their views on behalf of plaintiff? And again, as we have in prior hearings, I'll give everybody an opportunity to be heard. I won't limit plaintiff side to just one counsel. And then of course, I'll give the state the opportunity to respond fully. So Ms. Jones or Mr. Thierman, who'd like to go first?
Thank you, Your Honor. I guess I would like to start with clarifying. It seems to be that plaintiffs and defendants have a misunderstanding or don't understand exactly what, or the universe of people the court issued the contempt order on. Defendants argue it's just that 750 code, which based on the declarations, if it was just, or the information and the declarations from Mr. Schmidt at the contempt hearing, if it was just a 750 code, then it was far less than 9,000 people. And based on the new declarations, it seems that the universe is now up around 10,977. So I guess my first question is, because nobody, I can't tell, and maybe you can clarify this, Your Honor, is what the universe of people is, because if they've only paid 5,000 people out of 10, then that's not substantial compliance. Moving forward to your other questions, the 3 declarants are willing to testify today. I want to clear up a couple of quick things about those 3 declarants. Ms. Rabanowitz is not a hygienist. She works in dental insurance, just to be clear on that. Mr. Deschalette, last night after midnight, he received $6,250 in his bank account and an overpayment letter from D.E.T.R saying he needed to pay it all back within the period of like 2 hours. So I don't know what's going on with D.E.T.R, but it seems like when they pay somebody, they automatically turn around and send them an overpayment notice. So now all three of those people have received payment at least once, had payment stop. Mr. Deschalette actually got payment last night and an overpayment letter. So people are very, very confused. And I understand that the overpayment issue may be a little bit out of the scope of what we're talking about today. But from a claimant's perspective, it's extremely confusing. They are still unable to get a hold of anybody at D.E.T.R to find out, well, if in fact I am stopped for fraud or some other reason, what is it? I'll fix it. Just let me know. All 3 of these people have been trying to get a hold of D.E.T.R, have paid attention to their portals, have uploaded documents multiple times. And that's why we feel these 3 people are a good representation of the people that we believe, and the claimants also believe they're in the stop-start category, and that there is no clear and convincing evidence why their payment should not have been started. I still don't know what that number is. I don't know if it's 1,122 or if it's more like 3,000. I can't tell from the declarations in the chart. And maybe those are the concerns that we have starting going forward in the argument today.
Well, let's the court notes that. I'll hear from the state shortly in response to that. Let's go to the next issue, though, and with respect to, well, why don't you address what is the court to take away from Exhibit 3 to your filing with respect to the excerpts from the Consolidated Appropriation Act?
Sure. One of the issues, and that we didn't have admittedly, we didn't have this clarification, and Director Cafferetta alluded to some of the new clarifications in the new Appropriations Act. But D.E.T.R has always argued that they can't pay these people because the DOL will come in and tell Nevada that you're not getting any more money because you fraudulently paid these people. The waiver issue has been addressed both by the Nevada legislature and now this new legislation. And the reason why we included that is to rebut and enforce the argument that plaintiffs have been making from the get-go. AB 3 gave, our understanding of the rule, gave the director broad ability to waive overpayments or do determinations en masse to get money out to people. The whole point of the C.A.R.E.S Act was to infuse money to people that are not working through no fault of their own, to help everybody make sure their families are able to stay in their home, that small business are able to continue to operate, that money is infused into not only local economies, but national economies. Going back to that argument, the reason why we included that is because now with this new legislation, the Congress has agreed that those overpayment issues, the fraud issues are out there. But if a person has not done something fraudulently, meaning an intentional misrepresentation, that the state and the federal government are willing to let the state waive that so that these people can get paid. Pay the people now, which is what plaintiffs have always been arguing. If at some point you find out there's an overpayment or there's a fraud, go after those people then. Get that money into the economy so people can stay in their homes, so people can buy groceries. That is why we included section or exhibit number 3, to help the court understand that this is something that we've always been arguing, and it's not a legitimate excuse from D.E.T.R to argue that, you know, Nevada's going to get their money snatched away from the Fed based on their ability to pay people or their determination to pay people with the information that they've been provided.
Before I hear from the state in response to either of the two issues you've just addressed, let me observe this. At the end of this hearing, if the court determines the state remains in contempt, there will be consequences. Conversely, if the court determines the state now is substantially in compliance and the order of contempt to be purged, either way, the court's original order, order of mandate remains live. If through the next weeks, months, if plaintiffs believe that there are violations anew by the state in compliance with the court's order, if the plaintiffs believe that the state has not fully or is not now fully compliant based on new data points, new information, new approaches, I invite the plaintiffs to present that to the court, and the court will have a hearing and we'll bottom it out. But I want to make sure we're all clear. The purpose of the hearing today is to gauge the state's compliance with that group of people that the court found payments should have not stopped. The number, as the court understood it at the hearing on December 3rd, based on the testimony and the evidence, was somewhere north of 9,000 people. Now, just north, not double that, not 15,000, somewhere between 9 and 10,000. And what I'm hearing, at least what I think I'm hearing, is, Judge, 5,700 of the 9,000 plus we have restarted. 1,100 of the 9,000 plus we are doubling down on our belief that there is such sufficient, initial review, initial determination of fraud, that we have the right to not renew payments to those people. And as to the other 3,000 or so, those people, Judge, were being paid anyway, or have been paid. So they didn't have to be started again. You add all those up, Judge Breslow, you're up to the 9,700 or so that your order on December 8th encompassed. I didn't direct them today to review again that large bucket of people that the state had said the payments are not being resumed because they believe there is evidence of fraud. I specifically declined, I should say, at that time to find the state in contempt for its approach on those people that they maintain are not entitled to be restarted to benefits because of fraud concerns. Now, so while if you want to preview for the court now, that issue might, still be on the back burner, that it's for another look at another day, if ongoing evidence suggests to the plaintiff that the court should take another look at it, I'll certainly consider that. But for purposes of today only, I want to know whether the 9,700 payments have been resumed, all of them, most of them, some of them, and as to those that it has not, why not? And what I'm hearing from the state is 5,500, yes, 1,100 fraud, no, 3,000, no need to, because they were already being paid. Now, Mr. Ott, Ms. Cafretta, can you please respond to both what Ms. Jones said and as well as what the court's comments are? Start with Mr. Ott, and then I'll give Mr. Thierman a chance to explain his views as well. Go ahead, Mr. Ott.
To ask the question, make sure we're being accurate with what it actually states.
Overruled. Let's just get through this. I want to know what the facts are.
To find out what the facts were. I agree, the record's a mess.
Right, is there something else that's at issue here beyond the
In a nutshell, defendant's position is that each of the plaintiff's claims
(5:06 p.m. last night, counsel. The rules do not allow that.
Are there going to be other exhibits?
Thank you, Your Honor. So to go back to Exhibit 17, which is what we spent considerable time on, the 750 claims, as I think the court noted, was 9,841. Okay, so that number ties exactly to the number that is in the chart that we submitted on the 24th. The numbers were the court relayed were largely accurate, but the 1,122 for fraud is the larger number, which includes some people that were not in that 9,841 bucket.
Got it. You explained that initially. I understand.
Right. So, but yes, 3,037 were already being paid in UI or had their payments immediately started in UI. 865 plus I think 29 in the manual review were denied for fraud. So somewhere just south of 900. And then right about 5,000 were restarted in P.U.A. And that's of that 9841. Obviously the numbers, all those numbers are a little bigger when you look at other cases that were worked, and that's what Ms. Allender's declaration reflects.
Okay, Ms. Kefred, anything you'd like to add or stand by what Mr. Ott just explained?
I would stand by what Mr. Ott explained. I think he explained it clearly. I just wanted to add something about the overall program because I think there's a fundamental misunderstanding about what we're doing at D.E.T.R. So, one of our challenges is that we get new applications every day and we process applications every day. But overall, as of December 26th, the week ending December 26th, D.E.T.R has received 1,591,967 initial applications, 1.5 million applications. This is the week that we've exceeded the number of people we think are in the Nevada workforce that we have received initial applications for. So when we say, we consider a significant number of these applications to be fraudulent, it's either that or everyone in Nevada is no longer working. And just to the point of we need the money to be in the communities and helping Nevadans. We started the pandemic providing about 400,000 continued claims every week. So 400,000 Nevadans getting benefits. This most recent week, 276,855 Nevadans were getting weekly benefits. So it's been about 300,000 Nevadans week after week receiving their benefits. We have paid out over $7.6 billion in benefits, in unemployment benefits this year. So it is not an accurate characterization of our program to say that we are not providing Nevadans the money they need. This staff is doing an amazing job continuing to provide benefits to hundreds of thousands of Nevadans every week. And of course, those folks are just happy to be moving along with their benefits in their lives, and they're not calling us. But I just wanted to be sure that was on the record, that this team is doing an amazing job in, as you say, extremely challenging times. And we are getting benefits out to people. And a lot of these cases, as you've seen, are extremely complicated, and we're doing our level best to keep moving on them. Thank you for letting me make that statement.
You're welcome. And just to make sure I didn't hear numbers wrong, before you said before the pandemic, X amount of people were receiving weekly benefits. And my ears might have tricked me, but I thought you said 400,000. I don't think that's the amount of people you meant to say.
To clarify, the average weekly number of people getting benefits before the pandemic was 18 or 20,000. So we've gone from a normal year where we process about 20,000 benefit claims a week to a situation where we're processing 300,000 a week. The 400,000 number was the very beginning of the pandemic. So there was about a month or so.
All right, thank you for clarifying. Let me turn to Mr. Thierman because I haven't heard from him yet, and then I'll let Ms. Jones respond further to what you've just heard from the state. Mr. Thierman.
Yes, Your Honor, I turned to page 8 of your original order on the written mandate, and I don't see anything there starting on page 8 where it starts with the order limiting it to the 750 class. This is a new made-up classification or reason not to pay people. I think that this is problematic in the sense that D.E.T.R is constantly looking not to help people, but to deny people. And as far as the numbers are concerned, Ms. Caffaretta, I don't know if the original number of what you think is what the unemployable or employable people in Nevada is right. I do know that your staff has encouraged people to file multiple claims, because instead of taking a valid UI claim that's filed under P.U.A. and saying, hey, let me help you, you tell people nothing. And the other groups, Ms. Hansen's groups and others, say, well, you have to file under UI. So they file under UI, and they're denied under UI because it should have been some other program. So you have multiple claims from the same people. Now, I don't doubt that everybody's working 12 hours or 20 hours a day, but that's not serving the people of Nevada. I don't think it is. I think what it is serving the people of Nevada is, if you look at your systems for handling things, you'll find that you're not adjudicating in mass approval. The point of the whole, and I'll just echo what Ms. Jones said, that the point of this program is to put money in the hands of the consumer. And it's one injection point of many. We have the PPP loans that are being forgiven. That's $150,000 per business. That's just written off and forgiven. No accountability whatsoever. And we have other programs that are just, I mean, you can call them wasteful if you're a fiscal conservative, whatever, but that's the mandate from Congress. And that's the Keynesian economic theory that it's based on. And despite the fact that this economy is not doing well, I think it's doing a lot better than it could have been doing if we had not provided this kind of stimulus. But I think that there's something wrong where the goal or the desire is to constantly cut down the number of people who are considered eligible instead of increasing it. I would not subtract the people that you say were handled. I'll just strike that. I still don't know. I still don't have a clear answer whether these people are getting paid and are supposedly paid under this other program are actually getting paid, or are they simply eligible? I don't know if even D.E.T.R knows. And that brings us back to the UI P.U.A. whirlpool again. Maybe the system needs to be integrated. Maybe people need to help people fill out an application correctly. They change answers. That is, the computer changes people's answers because they changed the questions retroactively. And then they complain that there's no income earned when in fact there was income posted. Or they complain that the questions are answered incorrectly when the answer to the question was originally phrased was correct. So, I mean, I think there are systemic problems, but in terms of this court's order, there's nothing limiting it to the type group 70 or whatever, code 70. And I think that, look, I don't want contempt. I want people to get paid. I think you need to go back and look at this greater group and say, wait a minute, we were paying these people, we have to continue paying. And I believe Your Honor is taking the position that as far as you're concerned, the act of paying is finally the approval that fits under the JAVA. We have not abandoned our position that the initial determination letters, which should have been done within 3 months, 2 months, are the determination that ought to be ought to be the trigger event as opposed to just payment. And yes, the pandemic was a disaster. It was traumatic, but per state, it's no different than a hurricane or anything else under the D.U.A. regulations. And as the Supreme Court just recently said, you talked about the balance of the Constitution wins. That's what the Supreme Court said just recently in the Archdiocese case of Brooklyn. And I think
I think they said something like it might have taken a short vacation, but it hasn't turned into a sabbatical.
Yeah, I think that's what they said. I also said that, well, I don't know if that's what Gorsuch said or that's what the majority said, but yeah, But now the sabbatical's over. It's 9 months later. I mean, this is a problem. I mean, 3 months into it, everybody was saying, okay, we get it. 6 months, yeah. But 9 months, and we have one hearing, just one hearing. That's all we had out of 9,000 people.
Let's do this, because let me, I'll take responsibility for allowing people to identify their view of how things are going. I asked a rather open-ended question to the state on how things are going, and they had an opportunity to explain their view, and I'm certainly affording to the plaintiffs their view. But let me put the train back on the track here for a minute. As the court has observed in the last two hearings, there are competing appeals here. And the one for the plaintiffs, the position is the judge's order didn't go far enough. For the state's position, as I understand it, is the judge's order went too far. And at some point, the Nevada Supreme Court is going to decide that or something else related to this case. Meanwhile, though, this court's role now is to determine things that are ancillary to its orders and to not move forward on issues for which it has now been divested of jurisdiction. As everyone knows, one of the matters the court may continue to oversee is compliance with its prior order of mandate. That's why we had the hearing in December. The challenges were brought to the court's attention, but they didn't persuade the court that there had been a legal basis not to find it in contempt, and hence the court's order. This hearing is designed to see if the contempt should continue and if further sanctions should be considered, or if the court should find substantial compliance such that the contempt has now been addressed and purged. Again, whatever way that goes, that doesn't mean that you've lost the ability to circle back here and ask the court to consider whether new information, new approach, new data, new experiences are justifying a new look at whether the state has failed to meet its obligations under the prior court order. But for purposes of today, I'm looking at those people that had start-stop. And I fully recognize that there are people watching this hearing or who will otherwise learn about this hearing that are interested in other issues as well. And I recognize that. All I can tell everyone on this call or who may learn of this hearing is that this court isn't going anywhere. The court has limited jurisdiction at this point because of the competing appeals that have been taken to the Nevada Supreme Court. But if the court later learns, aside from whatever the decision is now, that there are issues with respect to the state's compliance with the law or prior orders of the court, I'll be prepared to address them. Now, having said that, Ms. Caffaretta and Mr. Ott, you have to admit that if what Ms. Jones says has been represented to her by one of the, I believe, Mr. Rabinowitz, that he received a payment about midnight last night for in the mid 5 figures, preceded by a letter asking him to send it back, that shouldn't happen, that would be frustrating, confusing, perplexing, and a few other words that probably are not suitable for a court hearing. But, that shouldn't be happening. And is there any level of assurance that the state is moving forward on trying to do what it can to make sure things like that don't happen again? Again, assuming Ms. Jones has her information accurately. Let's start with Ms. Caffaretta.
Thank you, Your Honor. We had, I was surprised to hear that because we had directed our staff to turn off those overpayment notices, particularly in the cases of the court, people that were getting paid under the court order, that they should get paid and continue to get paid. But I I guess it leads me to a question. We have always felt that in some circumstances, these folks would ultimately be found not to be eligible for the benefits they received. And so at some point would get an overpayment. I don't understand the court order at this point to say we cannot issue overpayments. I agree, issuing them simultaneous with the payments is challenging for individuals. And as I say, my understanding was we had turned that off. So we'll have to double check that.
Okay. Ms. Jones, or no, excuse me, Mr. Rott, anything else to add based on anything you've heard here in the last few minutes?
Yeah, I just want to correct one thing. Mr. Thierman said when we were off the rails, before you put us back on the rails, that there had only been one hearing. That is, of course, the one hearing in the manual review of the class of 9,841 that were included in Mr. Schmidt's chart. It does not mean there has only been one hearing period. So just want to make sure that he is not mischaracterizing things that or misunderstanding things. I don't want to be pejorative, but wanted to clarify that. And the other thing I would
let me stop you right there. It's because for those that are watching and interested in what's happening here, when you say there have been more than one hearing, what type of hearing are you referring to? What type of people are holding the hearings? Are they being held remotely? And what's your understanding of what's going on, Mr. Rott?
Yeah, and I apologize that I can't speak with tremendous authority on this. It might be something Director C.A.R.E.S can give more clarity to, because the hearings was not a substantial part of what I understood we were going to be discussing today. I just didn't.
Well, let me ask her then, Ms. C.A.R.E.S, do you have information on that? How are the hearings going? How many or so have gone forward? And these are people that have appealed their determination that they're not eligible for benefits or have had to refund money that they have received. Is that accurate?
So I believe that what's ongoing in the hearing world is plaintiffs or claimants are allowed to appeal any determination that we've made. We have been, for the whole time of the regular unemployment program, holding what are appeals, administrative level hearing with appeals referees. They are completely independent from the unemployment staff because they're doing an administrative law review. So they're independent. I'm with Greg. We weren't prepared with numbers to talk about the numbers, but they have been ongoing in UI since the beginning. We had to create the modules in the GSL program for the P.U.A appeals, and that we did those pieces in order. But those hearings started, I believe, in September, and we had to do a few initial tests to make sure we had all the computer programming components to record. And then we've been processing more each week, but they are ongoing. I think we have, I want to say, over 100 scheduled in the most recent weeks. And what we've found, just again to folks who might be watching, is that a great number of folks appealed their cases in P.U.A, but there wasn't a decision that had been made that was appealable. We've been reviewing those cases and just resolving them where it's not right for an appeal, basically, or an appeal hearing. So thousands and thousands have been resolved, and we have hundreds to get through in the appeals process, but we have been hearing those appeals.
Thank you. Mr. Rott, I cut you off. You said there were 2 points. One is that with the number of appeals going forward, so we've now clarified that somewhat. What else would you like to tell the court?
Trying to remember what my second point was. I think it was simply that the information that Ms. Jones was relaying came in last night. We don't have the letter. We don't have any of that evidence to be able to speak intelligently. So it's very difficult to respond when we don't have the information that is being referred to.
All right. So yeah, the specifics are beyond your reach right now, but we can all agree on this call that if it happened, it should not have, and a process examination should be taken if one has not already. Ms. Jones, what would you like to hear excuse me, what would you like to add based on what you've heard from Mr. Ott or from Ms. Cafretta?
Thank you, Your Honor. First, Ms. Rabanowitz and Mr. DeShillette are on the Zoom call, and they're happy to testify today. They're happy to say that, yes, they waive any confidentiality so that they can talk about this. So that's the first thing. The second thing I wanted to talk about is the appeal process. Since that's what we just talked about, I believe Director Cafretta said the UI appeals process has been ongoing since the beginning. The P.U.A module didn't get up until September. She is quoted in the Nevada Independent on the Exhibit 6 to our contempt hearing that no appeal for P.U.A even started taking place until November 5th. So I don't know if she's talking about UI appeals up to November 5th. We don't know how many, if any, P.U.A appeals have taken place from November 5th to the present. The second thing she said is that if you do not have an appealable decision, and that is a perfect example of Ms. Malia that we provided in the documentation last night. If your claim is in progress and has been in progress since May of last year, you don't have a denial that you can appeal. So she and many other people that don't have a determination have no ability to appeal. That was one of the things in the contempt motion that we talked about, is somebody tries to appeal and they're provided with a pop-up on the screen that says, you are not given this, what was the language? You do not have the ability to appeal, but it was something else. It was, you do not have this privilege. So it is not a privilege. Going back to what Mr. Ott said about one person in the 1,122 people actually had an appeal, I'd still like to know what that appeal means, because when you look at that chart, it says 865 were held for clear and convincing evidence of fraud. 280 received manual review and P.U.A. 3,037, which I think I'm hearing that those people are continuing to be paid, received a manual review and UI, and 29 received a manual review and denied for fraud. Manual review is not due process. The UIPL has been clear since 2015 that for determinations, including overpayment and fraud, the individual must be provided with a written determination which provides sufficient information to understand the basis for the determination and how and when an appeal must be filed, including the facts on which the determination is based. Provide the individual with an opportunity to appeal the fraud or overpayment determination. Continue to make timely UC payments if due, and wait to commence recovery of overpayments until an official determination of ineligibility is made. That is part of our Exhibit 1, that UI, the DOL UIPL 01116. Furthermore, for making a fraud determination at page 6, it is incumbent upon a state to make further contact with the individual, inform him or her of the conflict, and allow an opportunity for rebuttal. Because such factual conflicts require the state agency to make determinations of credibility and intent, determination of fraud must be made by agency staff. The determination may not be made by an automated system. So if D.E.T.R is saying that they did a manual review, that does not mean to me that they called those people and they gave them an opportunity to rebuttal. So at least 869 people that were stopped for fraud under this court's contempt order should be restarted until they have that opportunity. From my reading of the chart, only one person was actually provided due process. So going back to getting on the rails of this particular contempt hearing, over 1,100 people, that's a lot of people that should probably be paid under the court's order. And I would hope that they will be started to be paid until they are allowed their due process rights. Specific to the ongoing appeals at the Supreme Court, the state just filed their cross appeal and their reply last night. Ours is due on the 13th of January. I'm wondering from you, Your Honor, when you said that if plaintiffs are seeing from claimants that they're continuing to have these problems and the court will revisit those issues. I know I've said a lot here, but I'd like a little direction from the court. In what form? Do you want us to add them as plaintiffs? Do you want just declarations? What procedurally does the court suggest we do? And again, if you would like to talk to Mr. Deschlett or Ms. Rabanowitz, they are on the Zoom call and they're happy to speak to you today.
Okay, let me respond to a few things you said. First, to my comment earlier that the pandemic has, because of its severity and breadth and the realities, in some respect, people's constitutional rights have been temporarily relaxed. But I use the phrase, but they're not asleep. So the court is trying to find the right balance. That's why, Ms. Jones, in the July order, the order of mandate, I made a determination that payments once started could not be stopped unless the state possessed clear and convincing evidence of fraud. I intentionally didn't say, after appellate review as otherwise allowed under unemployment insurance protocol, standards, law, authority, precedent, because the court didn't find that to be what the law required at this time, nor otherwise fair and just. The court hit in some respects, a middle ground that I felt was consistent with the law, the spirit of the law, and the realities of the world that we now live in. This court hasn't changed that order. The court order, which still governs the parties' relationships here, is if the state believes it has clear and convincing evidence of fraud, it may stand by its decision not to resume payments. Court didn't say payments must go forward until a hearing in person has occurred. Now, does that mean the court might not get there? No, because if the court learns of what I would determine to be undue delay, failure to move claimants forward fast enough in the appeal process, inability to handle the avalanche of those whose benefits have been denied or stopped, who are entitled to an in-person hearing. If I find that their rights are being so trampled, the court will take another look at that. I'm not there today, though. I'm not there today. I mean, I know people want to argue about whether the fraud stop issue is something that the court could take another look at, whether it allows the state to avoid paying those people at this time. The court's not here to do that right now. The court's to determine if the 9,700 people that had their payments stopped have had them resumed, either with the P.U.A. or the unemployment, the standard unemployment insurance program, or the state believes it does have clear and convincing evidence of fraud, which it's more than a quick look to determine if there's evidence of fraud, but it's less than a full briefed in-person evidentiary hearing. It's somewhere in between. That's as fine of a point as I can put on it right now. That's number one. Number two, After the hearing today, Ms. Jones and Mr. Thierman, if you believe that the state is running afoul of the July order of mandate, then I would encourage you to pick up the phone and call Mr. Ott, and with his permission, Ms. Cafferetta or other senior administrators to try to find out if there's a way to work out the problem. Third, with respect to those that took the time to provide declarations to the court on behalf of plaintiff, who are obviously watching this hearing, who have a story to tell and they want to get it out there. I understand that. I know they're very likely both frustrated with the way they've been treated and anxious for people with authority to do something about it to hear their story. But I'm going to pass on that right now, and here's why. I'm not trying to diminish their frustration or what they're experiencing, or others that might be in the same boat. I want to explain to them, though, that the court's role here is to determine whether the state has impermissibly failed to do what the law requires. And that's why the court held them in contempt 3 weeks ago. And that's why we're having this follow-up hearing. Now, are there people who unfortunately have what I believe the state would say are one-off experiences? Probably. Is it systemic? Is it the way that they're approaching the law? Is it the way they're approaching the court's order? Well, if I felt that was the case, there'd be a price to pay for that. But if I hear from 2 or 3 people now who have maintained that they're being left behind, or that they should have been captured but not, that's not going to really move the court's needle. Having said that, I certainly encourage the state to review review fully their 3 experiences, and if they feel compelled to do so, or I should say inspired to do so, to give those a close look. All right. Having said all this, I'm going to allow final argument on what the court should do and why the court should do it. Mr. Ott, right now the state is asking the court to purge the contempt citation. Has anything you've heard so far this morning changed your view of things? And whether it has or has not, what are you asking the court to do today?
No, Your Honor, nothing I've heard today has changed our position. I do think it's important to clarify, because there's been considerable discussion about those 800 or 900 people who were in that 750 who were held for the fraud. No changes were made to the existing processes that were debated at length in December 3rd about, and Mr. Bracken came in and testified. Numerous people came in and testified for the court about how things were done with regard to fraud. None of that was disturbed with regard to the review of these cases. When Mr. Schmidt talked about things having multiple different issues with them, we wanted to make sure that we didn't make any changes to a system that you had found we were not in contempt on. So to the extent that the court has any concern about us saying, oh, well, using a shell game, for lack of a better term, no changes went to those fraud determinations and what the court spent considerable time on. So we still believe that the 750 holds have been dealt with in the manner explained in Mr. Schmidt's chart and Ms. Allender's declaration. We know that there are additional people out there and additional cases that need to be worked. Dr. Cafferata talked to the numbers. Those are continuing to be worked. But as to the contempt charge, I think the evidence is clear that it's been purged. Nobody's showed anything otherwise. And those other issues, like you said, do not necessarily go away. There's new law on the books. There's a lot of new issues that are around. But as to the issue that we're here today for, which is the purge of the contempt, I think it's pretty clear that that's been purged, and we'd ask you to find so.
Thank you. Ms. Jones, response.
I believe Mr. Thierman was going to close.
Okay, thank you, Mr. Thierman.
Okay, first of all, the shell or the bait and switch is it's not 9,000 people. It's probably 20,000 people. All we know is that the people who are 750 are 9,000. The order, you were very careful in your order. You're very careful in your language. You've been careful in your language throughout. You've chosen your words carefully and properly. You said nothing about this being limited to the 750, code 750. Code 750 is the whirlpool of the conflict. That's what they have now limited the universe to. That's not what your order limits it to. So I think you're not done. You're not ready to make a decision until you get real numbers. And, you know, they use words, qualifying words. D.E.T.R uses words like how many, oh, we have hundreds of scheduled. How many have you had? We have people who are eligible. How many have you paid? I mean, let's drill down and stop with the bureaucratic, you know, newspeak or whatever they want to call it, 1984 language. They haven't paid a lot more people who had stop starts than they indicate. And until you get those numbers, you're not in a position, I would say, to make a final decision. On the other hand, again, $1,000 isn't going to do, you know, anybody any good. And 9 months later, for, you know, telling us we can bring another contempt hearing is kind of defeats the whole purpose of this program. The whole purpose is to get the money to people when they need it now. When everybody's got a vaccine and people are traveling again, you know, this may be irrelevant, but it will leave some people wrecked, and we get those calls. And the number of people who aren't getting paid, Ms. Jones is conservative when she says that it's 200 people or so that have called us or have called the other P.U.A. Facebook pages. And the news is running things in Vegas all the time about it. People who have not get paid, they would stop. So every time we go into these things, we get these qualifying words or these newspeak that basically deters you or prevents you from drilling down and finding out what really is going on. And until we get some honest answers, I think that you should hold the thing over their heads and tell them to go back. And if they come back and say, oh yeah, it was 20,000 people, we paid them all now, hey, then I've done my job. And, you know, then I think the court's done its. But you made a decision. You were very careful in your language, and they're not following it, at least as to now. And they're not telling you they're not following. We don't have any discovery in this case. They're not telling you they're not following it. They're just giving you half truths and half the information. So, and it's kind of a bait and switch thing. I don't know how many people. Well, no, that's the other thing. Ms. C.A.R.E.S says, well, there are thousands of people who filed an appeal and we just decided we're not going to hear it. I'm offended by that. That's not resolving it. That's just them dismissing it without giving people a hearing. So that's, to me, not only irrelevant, it's unconstitutional. People file a hearing, they get an in-person or a Zoom hearing with an ALJ. That's the way it's worked since the 1970s, you know, from Kelly v. Goldberg v. Kelly. And that's the way it ought to work now. And yes, it is. I don't know if our constitutional rights were asleep or just people were so shell-shocked they didn't know how to assert them. But it's 9 months now, and it's time we brought these things back. And then I'll let Ms. Jones finish with the actual statistics, because she's much more on top of that than I am.
All right, Ms. Jones, you can briefly address the court, then I'll hear final thoughts from Mr. Ott, then the court will make a decision. Ms. Jones.
Thank you, Your Honor. I just find it hard to believe that when they provide a chart like this, that it provides the court with proof that all the start-stops have been paid per your contempt order, especially when Mr. Ott and Ms. C.A.R.E.S admit that there are claims that continue to be worked and continue to be looked at, but we don't know how many claims those are. So if the court determines that defendant's D.E.T.R has substantially complied, then I guess we will be back in front of your court with multiple additional claimants with declarations saying that they haven't been paid on your contempt order, which is it doesn't seem to be a good use of the limited resources of the court, the limited and strained resources of D.E.T.R, and the limited and strained resources of plaintiff's counsel. However, I believe that all three of these parties owe it to the citizens of Nevada to do everything they can to keep them in their homes and to keep them out of food banks and to keep them just functioning. And so that's what we'll do.
Thank you. Mr. Ott, final words, please.
Just briefly about the hearings. It's not a unilateral denial of anybody who brings a claim and wants to have a hearing. But when somebody files a request for a hearing that just says, I need help with my claim, that's not an issue that can go to a hearing officer. So there are things that get filed that just don't rise to an issue that can be moved on to a hearing. I don't want to go into all the minutia, but I think the order after the hearing, the court's order was clear. It asked to focus on the 750s. That is what we did. I understand the order of mandate has not gone away, and D.E.T.R continues to prioritize those other claims as well. But with regard to the 750s, which is the language that was in the order of contempt, those have been dealt with in the manner that has been explained to the court.
All right, thank you very much. Well argued on both sides, well presented. In making the determination, which the court will pronounce momentarily, the court has reviewed and considered how we got to this point. I went back and looked at the minutes from prior hearings, the prior court order, the hearing from December 3rd, the order of December 8th, and the recent filings. The court is extremely pleased that current administrator of the Employment Security Division, Ms. Parvin, sent out the administrative memo as she did on Exhibit 1. Rhetorically, the court is curious why there wasn't a similar memo 3 or 4 months ago from a prior senior administrator, but you know what, it is what it is. So the court is pleased that that has been made clear to all people who are involved in processing applications for benefits, that is now their directive to march by. The court has considered Ms. Allender's declaration. It was clear to the court when I heard from her in early December that she's a very hardworking, loyal state employee who takes her job very seriously and tries to do it as well as she can and help supervise others do theirs. Court has reviewed the chart, which attempts to reconcile where the state stands with the information provided in particular by Mr. Schmidt, chief economist, back in early December. On the other side, the court has considered the declarations of the 3 individuals the court previously identified and has considered their unfortunate experiences and the effect that it's had on them, and as well as the effect it has on this court's determination today. Recognizing full well that I didn't have them testify and allow the state the opportunity to question them to see if there was a substantive response to some of the concerns. I understand that. Court has considered the information provided by Ms. Jones in the recent filing about a week ago from the Plaintiffs' Counsel to, remind and reinforce to the court what the law is, what the law requires, and how the people that are claiming benefits here, in some instances, have not been afforded all the rights the law would otherwise provide for them. So the question today is the state in continuing contempt? On balance, the court determines the state is not in contempt any longer. The court is persuaded that its actions reflect and demonstrate substantial compliance with the prior order of mandate from July, as clarified and reminded by the court's order of December 8th. So the court purges the contempt citation. The state is no longer found in contempt. The prior order to make the $1,000 payment to Washoe Legal Services, however, stands. So where are we now? Well, first of all, the court strongly encourages collaboration between counsel for plaintiffs and counsel for the state. And if the counsel for state will allow it, perhaps senior executives in the Employment Security Division, or D.E.T.R, to attempt to identify continuing issues that may reflect people who are one off or two off or many off that ought to not be experiencing some of the delays, frustration, and concerns as evidenced by people like Mr. Deschalet, Ms. Rabinowitz, and Ms. Leah. Now, again, there's often two sides to every story, sometimes even a third, but so I only know what I read that they explained happened to them, and I only know what Ms. Jones advised today, what Mr. Deschalet apparently experienced last night. But, I strongly encourage dialogue so that there are no more or many less people like them that feel compelled to file declarations in support of their view that the state is failing at its job. I strongly encourage the state to move forward as robustly as it can to begin processing appeals, formally processing appeals for those that have sought an appeal and for whom an appeal is otherwise available. As Mr. Ott explained, many people are seeking appeals, but their cases or their situation is not ripe for appeal. But even then, the state is attempting to take steps to resolve their concerns. Now, that doesn't mean that everyone who's denied benefits needs to seek an appeal just so they can get some more personalized attention to their situation, because, I only imagine the system would be overloaded. But if there's a way to confirm that appeals are moving forward as rapidly as they possibly can, I encourage that dialogue so that it's not yet another motion, opposition, response hearing with a subsequent request of plaintiffs to find the state in contempt for that reason. The people being held up because of fraud, that continues to be a sore spot. A, because it's so many people, and B, because the court has already said it's a between the goalpost standard here. It's more than just a sniff or a sense that somebody is claiming something knowingly false or misleadingly false. But it's not at the other end of the goalpost a determination, a full due process determination with a hearing officer. So in many respects, I'm relying on the state when it represents that it has gone forward and determined X amount of people are captured in the clear and convincing evidence of fraud bucket to justify the lack of payments I am relying on the state at this point, in good faith, to do its job and so identify people. But over time, if hearings don't work their way through, and if that bucket continues to grow, and if Mr. Thierman and Ms. Jones present the court with more than slight evidence that this has become a systemic problem, and I realize they believe they're already there, but the court disagrees. But if it continues much longer, and if more people surface that are being captured in that bucket with very simple explanations with respect to their identity or documents to confirm that, then I'll take another look at the way the court has defined the right of the state to withhold benefits. But right now the order stands, and I do not find the state in contempt. At today's hearing, we really weren't set for that anyway, but I confirm the prior determination of the court. But again, that doesn't mean the court could not be inspired to take another look at it in the future. So that really concludes the court's remarks. The contempt citation is purged. Substantial compliance is found. It's obvious that some issues still remain. Court encourages dialogue on that. That will be the order of the court. I'm not sure when a formal order will issue, but the order stands as of now, as orally pronounced. Mr. Ott, before the court thanks everyone and concludes this hearing, anything else from the state?
I don't believe so, Your Honor.
Thank you. Ms. Jones or Mr. Thierman, let's start with Ms. Jones. Anything else from plaintiffs?
No, Your Honor, I would just tell everybody to hang in there.
Both on and off this hearing, right? Those participating as well as those watching. Okay, a little levity. Mr. Thierman.
Nothing further, Your Honor.
All right, thank you very much. To each of you, a happy new year, good health. The court will be in recess. Thank you, everyone.